Okay, welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge. On the panel today, we have Judge Sasso and Judge Nardella. We are streaming live on YouTube. With that, we have case number, it's 11 a.m. We have case number 22662, Remator versus Bank of New York Mellon. And I'm sorry if I mispronounced your client's name there. You can correct me when you begin your argument if you'd like. With that, I believe we're ready to begin. And counsel for appellant, if you'll just let me know how much time you'd like in rebuttal, I'll attempt to remind you.
Sure. I would like 8 minutes for rebuttal, please.
8 minutes. Okay. You should watch the clock as well, but I'll try to help you watch it. And with that, whenever you're ready, you can begin.
May it please the court. My name is Michael Votter of the Ticton Law Group, here on behalf of the appellants, Chandra and Dakoli Ramatar. What we're here on is a simple issue related to the right of the defendants in a mortgage foreclosure case to recover their attorney's fees following a voluntary dismissal by the bank. And the Page versus Deutsche Bank Florida Supreme Court opinion, which was just released earlier this year, is very instructive because it outlines 3 requirements that must be met: that the moving party is the prevailing party, that there's a fees provision, and there's a contractual relationship. The appellee has only raised the issue of the defendants, the appellant's position that there was a general denial of the allegations of the complaint as the reason why attorney's fees should not be met. So here we have the moving party is the prevailing party. There's no question of that. There is a fee provision in both the note and the mortgage, and a contractual relationship exists, as was shown in the record. Now, there's a case that's most applicable, and that's a case that I was actually involved with, both at the trial level and as appellant counsel, and that's the Grosso versus HSBC bank case out of the 4th District Court of Appeal.
Would you agree in Grosso that there was a specific endorsement?
I agree that there was an open endorsement in Grosso, but that's not the issue here, because here we have an affidavit by the bank saying that they're the owner of a lost instrument. So there's a lost instrument that they aren't otherwise entitled to enforce.
Wasn't that allegation disputed here, though?
You're correct. There was a dispute, and it was raised in the standing defense. However, similarly to the Venezio versus JP Morgan Chase Bank case in 2019, the 4th District Court of Appeal said that when there's a voluntary dismissal, it prohibits the court from making a judicial determination of either party as being a party to the lawsuit.
Well, let's step back some. Would you agree that the party moving for attorney's fees has the burden of establishing that the plaintiff is a party to the contract or entitled to enforce the contract that contains the attorney fee provision on which the defendant relies?
Yes, I do.
Okay. And what is the burden? Is it a judicial determination? Is it undisputed evidence? Is it anything in the record, regardless of whether or not it's disputed? What is the plaintiff required to, or the defendant required to show?
Well, the Grosso case is instructive because in Grosso, it said the burden was to be able to establish record evidence. The record evidence that I established at the hearing that was the mortgage, the note. There was also an affidavit of lost note, which is a sworn testimony by the plaintiff's representative that they were the owner of this particular instrument.
So would we have to, if we apply the Grosso rule and analysis, which we of course are not required to do, would we adopt a rule that anytime there is evidence in the record, regardless of whether or not it's disputed evidence, that could support a judicial determination that the plaintiff was a party to the contract, that is sufficient to sustain the defendant's burden of proving entitlement to fees?
Yes, unless the plaintiff presents evidence in the contrary. And here the plaintiff
doesn't that flip the burden though?
No, it doesn't, because what I'm doing is the defendant's meeting their initial burden. They're they're presenting evidence to this court that shows, or presenting evidence to the trial court that shows that that initial burden has been met. But the issue in the Appellate's brief is that it's not them, it's that it's not the homeowners. And there is record evidence to show that it is the homeowners, because there is the mortgage and the note, which was admitted and considered by the trial court as record evidence showing that the homeowners were parties to the contract. See, in the affirmative defenses, the homeowners not just raised the defense of standing, but they also raised the defense of failure to comply with conditions precedent. So in order to have a failure to comply with conditions precedent, you have to be able to be a party to that particular contract.
What's the effect of your second affirmative defense regarding standing?
Sure. The second affirmative defense is a general defense of standing. I note in paragraph 8 of my defense, we raised that the owners did not take out a mortgage or execute a promissory note with the plaintiff. Well, that makes a lot of sense because the original lender in this case was Wilmington Finance, not the actual plaintiff that was bringing the action. But the standing defense, we don't even, if we look at Page, Grosso, Venezia, all those cases, standing was raised as an affirmative defense, and still the appellate courts found that there was an entitlement to attorney's fees.
But why, help me understand that, right? Why should a party be able to take a position in the litigation, in their answer, and then take the opposite position when we're in a fee proceeding?
Well, at the end of the day, it's an issue of fairness in that the Page Court is very instructive on this, the Florida Supreme Court, in that it would be inequitable to allow a party that would prevail in the action, the plaintiff, to take the benefit of the fee provision. They're the ones that bring the homeowners, the defendants, into court, and the defendants have to have the burden to show affirmative defenses. But here we are in a case where there's a voluntary dismissal. It then leaves the court's jurisdiction to make those determinations because of the fact that we don't get to actually have a trial or have a summary judgment. The case is not decided on its merits, and it would be inequitable to then not allow the defendants to get the benefit of that fee provision in the original contract.
Equities, though that this is not a situation where the legislature has kind of accepted that equities argument and had a statutory prevailing party provision in foreclosure cases. It's a statutory provision allowing reciprocity of a contractual attorney fee provision. So I think the legislature, in passing that statute, and I think the case law is clear, that it presumes that there are at least two parties to a contract that are involved in the litigation. And so why would we adopt a standard that essentially, I think under your standard, and correct me if I'm wrong, maybe this is my question, under your standard, isn't it possible that just by virtue of a voluntary dismissal, a party pleads that they're a party to the contract, the defendant points out they're not, the plaintiff takes a voluntary dismissal, and then a defendant could then get fees based on a contract to which the plaintiff is actually not a party to? Isn't that a possible scenario if we apply this rule?
Sure, and under 57.105 subsection 7, and the interpretation under Page, that is the interpretation by the appellate courts, especially the Florida Supreme Court, in terms of the application of attorney's fees, because in Page, they didn't find that Deutsche Bank was a party to the contract. And the Florida Supreme
Page was different because wasn't the certified conflict in Page where there was a determination that the party had standing at the time of trial, but not at the time the suit was instituted. That was the conflict that the Florida Supreme Court was evaluating, correct?
That is correct. But we don't even get to have a trial here in this particular case due to the voluntary dismissal. So just like in Venezia, we never get a judicial determination.
And I agree, but doesn't that change the question then that was presented in Page? In Page, there is undisputed evidence that both the parties, plaintiff and defendant, were subject to the contract at some point. Here, wouldn't you agree that at best the evidence is undisputed? Or sorry, that at best the evidence is disputed?
Well, the evidence that was presented in this particular case was undisputed evidence, because remember, the allegations are simply allegations. They're not to be considered evidence. There was no sworn interrogatories, deposition testimony, any other type of evidence, such as what was in the Red Road case, which is relied upon by the appellee, which put that issue into dispute or presented other evidence to the contrary. We've never had any evidence presented that the plaintiff or the appellee was not a party to this contract, and nor was there any evidence that the Ramitars were parties to this contract.
So without the lost note affidavit, would you be out of luck here?
Without the lost note affidavit, yeah, I would be able to present the evidence subsequent where there was a later assignment of mortgage, but the lost note affidavit is an admission by the party. That's the best evidence. I don't think I would necessarily be completely out of luck. I think it would just make my job a lot harder.
You would have to establish that you could sort of present evidence after the dismissal, correct?
Correct. If there was other evidence that had been presented, and I know the courts routinely, especially the Third District Court of Appeal mentioned in the Radosevich case, the parties are to present evidence after the dismissal in that case to determine whether or not there had been a settlement that had been reached. So our position is that it would not be inappropriate for the trial court to consider filing evidence that may have occurred after the dismissal. So basically, the main contention brought up by the appellees is whether or not the Ramitars have presented sufficient evidence to show that they are parties to this particular agreement, and based upon
counsel, let's say for a moment that your defense is in your pleadings. Let's say for a moment that it was very clear that your client had taken the position that they never signed this note, which, by the way, I recognize that the appellee's brief spins it that way, but I do recognize that that's not what your defense said. But let's say that it did. Let's say that your client took the position, I never signed this note. That's a fraudulent signature. But then after the dismissal, your client obviously wanted to get fees, and so therefore said, "Oh no, wait a minute. You know, I was a party to that note." Does that fly?
I don't think it does, because we have that case out of the Third District, which is cited to by the appellees, the Red Road residential case, which states that when a primary defense is based upon forgery, there's sworn testimony, there's deposition, there's interrogatory.
In that case, didn't that case go a lot farther, right? I mean, wasn't there a judicial, I can't remember, maybe I'm wrong, but was there a judicial determination in that case?
There was no judicial determination because it was also a voluntary dismissal, and I see I've reached my time.
Okay, counsel, so you'll save the rest of your time there for rebuttal. And with that, we'll move to counsel for the appellee. You're recognized whenever you're ready.
Yes, thank you. Good morning, Your Honor. Eric Levine of Ackerman, LLP, here on behalf of the appellee, the Bank of New York Mellon Trust Company. May it please the court. The appellant's presentation completely misses the mark and raises issues that are really not properly before the court. So the trial court's order denying fees, the actual orders entered by the trial court denied fees to the appellants for one very specific reason. It wasn't, as counsel tried to imply, because the bank lacked standing. The trial court denied fees to the appellants because the appellants denied in their answer they signed the note and mortgage. And where did they deny that, counsel? And are you talking about their general denial? The general denial is denying all allegations of the complaint, which includes the allegation that they signed the note and mortgage. But here's the problem with the argument is the trial court held that they were bound by that general denial. That was the trial court's reasoning. And before this court can even get to the question of whether or not the trial court erred in its reasoning, it needs to determine whether or not that issue is properly before the court. The problem for the appellant is their initial brief never raises any issue as to the trial court's holding. It never asserts any error with the trial court's holding that they were bound by their denial. And since the actual holding of the trial court is not raised in the initial brief as error, it's considered abandoned on appeal. The sole basis for the denial of fees is not disputed one time in the initial brief. It's the entire initial brief is the bank should be allowed, they should be able to hold the bank to its allegation that it is a party to the note and mortgage, which page implies under certain circumstances you can do. But the initial brief never asserts error with the trial court's finding that the defendants are bound by their denial. Now, in this case, that should be the end of the inquiry. If they haven't properly asserted error with the trial court's holding in their initial brief, the fact that he brings it up in the reply brief or oral argument is not proper before the court, and the court shouldn't even reach the issue and should affirm on that basis alone. But let's move past it for a second, because I'm sure the court wants to talk about the actual merits of the trial court's decision. And it's a very basic holding of law that says a party is bound by their pleadings. In this case, we all know that Florida follows the American rule that says generally all parties bear their own fees. That's the Torella case from this court of last year. And that all statutes and contract provisions that award fees being in derogation of the common law are strictly construed against award of fees. So let's take a look what happened in this case. Now, in Page and Mr. Vodder's argument said there has to be a contractual relationship. They have to show that both they, the appellants, and the appellees are both parties to the same contract. Well, let's see what happened in this case. As required by Florida Rule of Civil Procedure 1.110F, Bank of New York Mellon did plead in paragraphs 2, 3, and 4 of its complaint that the ramateur signed the note and mortgage and the loan modification agreement. In response to that, in violation of Rule 1.110, where a defendant is supposed to specifically respond to each allegation, you're right, Judge, they gave a general denial that says, we deny all substantive allegations and we deny all allegations not admitted. That's what they said in their answer. So they clearly deny.
Did you file a motion?
I'm sorry, what kind of motion?
If you thought their answer was insufficient, did you file a motion?
No, we did not file any sort of motion. But also keep in mind that answer is signed by the same counsel they have here, not Mr. Vodder, but by his law firm. The answer signed by the Ticton Law Group under Florida Rule of Judicial Administration 2.515A, that signature by the lawyer is a certification that there are good grounds for the denial. So not only do the ramateurs deny in their answer signing the note and mortgage and loan modification agreement, their attorney certified there were good grounds for the denial. The trial court took that denial, applied the Florida Community Bank versus Red Road residential case and said, you've denied signing the note and mortgage. There's a voluntary dismissal. You can't meet your burden of pleading and proving you're a party to the note and mortgage. So the fees were denied in this case specifically on the basis that the ramateurs were not parties to the note and mortgage. Now, of course, Your Honors, we recognize that denial is absolutely frivolous. We recognize it was a frivolous denial. But a frivolous denial or not, they're bound by that denial.
Well, if that was the actual denial, so going to their initial brief on page 21, they argue that the copy of the promissory note and the mortgage are proof that the homeowners is a party to the contract because the homeowner's initial and signature is on both documents. And then goes on to explain why the bank was also, so why is that not sufficient to challenge the trial court's determination that they had denied that they were parties to the contract?
Because all they say is there's a note and mortgage that has the ramateur's name on it. Obviously that's correct, but they don't explain why they denied signing it in their answer. They don't explain why they shouldn't be bound by that denial, and they don't explain why the trial court's reasoning was denied. Now, the trial court cited, I believe, the trial court itself is the one that cited Florida Community Bank versus Red Road Residential in its order denying fees. And you would think that if that was error, the appellants would cite to that case in their initial brief and explain why that holding was wrong. The Red Road case is not cited at all in the initial brief. And so under standard rules of appellate procedure and appellate review, if they have failed to assert error with the trial court's actual holding and reasoning in the initial brief, it's deemed abandoned. Now, under the party presentation rule, the courts look at the papers and pleadings prepared by the parties as they're presented. In this case, the Ticton Law Group chose to put a denial of all allegations in their answer. signing it, certifying there were good grounds for that denial, and chose to not actually assert error with the trial court's holding in their initial brief. I mean, look, if you actually sat down and compared the trial court's orders with the initial brief, you'll see the initial brief never challenges them on any of the reasoning raised, any of the bases actually held by the trial court. That's an abandonment. So in this case, my first argument in our answer brief was one, they're bound by their denial. The trial court did not err in denying them fees, because a parties has to be bound by what they say in their pleadings. And if the appellants are going to frivolously deny signing the note and mortgage in their answer, then they should be bound by it. The second aspect that we also raise in the answer brief is the fact that the appellants never actually moved for fees. If you look at their motion, they actually moved to tax attorneys' fees as costs. They cite 1.420D, and their motion talks about how attorneys' fees are costs because they're defined as costs in the mortgage. Now, that's obviously incorrect. The mortgage does not define costs, attorney fees as costs. They define it as expenses, which is separate from costs. Now, I do recognize that counsel tried at the hearing on this matter before the trial court to correct that and say, oh no, we're not arguing it as costs. He did say that at the hearing, but that was of course too late. It's akin to making an argument for the first time at oral argument and not in your brief. So the failure to actually move for fees as fees is also fatal to.
How do you square that argument with Caulfield versus Cantel and the related precedent that the failure to plead the basis of a claim doesn't result in a waiver? Is your argument that there wasn't a specific basis, there was just no claim at all for attorney's fees?
That, because there's two different things we're talking about. There's the Stockman standard that says you have to plead it in your pleading. In your pleading, you have to say you want fees, and you don't need to be very specific in your answer or your complaint. That can be kind of general. But once you prevail, once you get to actually asking the court to award you your fees under Rule 1.525, which was not the motion filed in this case, at that point in your motion, you have to specifically identify your basis for fees. It's not enough to ask for it generally. So there's a difference between the pleading requirement to keep the issue alive in your answer or your complaint versus what you need to put in your motion at the end of the case to actually get the court to award you fees.
In the motion, they expressly asked for fees. And if I recall, I don't have it pulled up, but if I recall correctly, they did cite the statute. Am I misremembering?
No, you're not misremembering. They cite the statute.
Why is that not enough?
And additionally reference the mortgage and note. So why isn't the statutory citation with reference to mortgage and note sufficient?
Because they cited the note and mortgage in the statute for purposes of reciprocating it as costs, not as fees. Again, it's the party presentation rule. They drafted their motion this way. They said,
but again, that answer doesn't address the question. The question is, they expressly asked for fees, and while they didn't necessarily cite the correct rule, they cited the correct statute and the documents. Why is that not enough?
Because they cite those documents in the context of moving for fees as costs. And they specifically say, if that was just it, that might be okay. But if you read their motion, they specifically say attorney's fees are, I'll pull it up right now. I have some printouts. Motion to tax attorney's fees as costs is page 114 of the record. And if you look at pages, on page 115, paragraph 7 and 8, the note and mortgage provide that costs also include attorney's fees. The Florida Supreme Court has consistently held that where a statute or agreement of the parties provides the term costs include attorney's fees, such fees and taxes are taxable under Rule 1.420D. So yes, they cite the statute and the contract, but they cite those in the context of asking for attorney's fees as costs under Rule 1.420.
So your argument hinges entirely upon that they didn't cite the correct rule of procedure.
Well, it's not just citing it. They didn't move under the correct rule of civil procedure. They specifically moved under a different basis. But as
what's the difference between moving under it and citing it in their motion?
Because they cite it for the purposes of advancing their 1.420 motion. But I recognize that that's a very technical argument based on.
Can we go back to their answer?
Sure.
And look, I mean, I don't dispute that had you filed a motion that this answer probably would have been stricken, right? But as far as their general denials, if we're not talking about their second affirmative defense, it's unclear to me where exactly they deny that they signed the note and mortgage. I mean, I understand it says they deny all substantive allegations. I mean, there's sort of that general, very broad statement. But I mean, other than that statement that, hey, we would deny all substantive allegations, where do they deny specifically that they signed this particular note and mortgage, as opposed to deny that, hey, we signed it with this bank?
Well, I would also point out paragraph 4 that says any and all allegations of the complaint which are not explicitly admitted are hereby denied. So it's paragraphs 2 and 4. You're right. They don't specifically.
But I mean, right. I mean, I hear what you're saying, right? I mean, look, you have a reasonable argument, but on the flip side of it, when you don't go and require them to answer each paragraph specifically, and you sort of let this go, there's not much to latch on to as to exactly what the denial is. Were they denying we didn't sign this note at all? That signature is fraudulent, or were they denying we didn't sign this note with this bank?
Well, I would submit that I recognize you're correct in the answer part of it. They don't specifically say we denied signing the note and mortgage in those words. They simply deny all allegations of the complaint, both the substantive and anything.
But your allegation was they signed the note and mortgage, and that you're entitled to enforce it, right? So what were they denying?
They were all of it. The Rule 1.110 require the reason that the 1.110 is written is it says all denials have to fairly meet the allegation of the complaint. If they were only denying standing and admitting signing,
so you didn't sort of force their hand to actually do that, right?
We didn't, but I mean, it's their violation of Rule 1.110, and now they're trying to seek cover for their own violation of the rule and saying because we violated the rule and didn't properly phrase our answer, we should be rewarded for that and not be tagged for what we did. And I just don't think that's proper, especially under a procedural posture where they have the burden of overcoming the presumption of correctness, which they can't meet because they don't actually challenge the trial court's holding.
Your whole argument is that they denied signing the note, and it's just not entirely. I mean, look, had you forced them to deny specific allegations, but I guess my point is that what's the allegation they're denying? Is it just the note that we didn't sign it, or is it we didn't sign this note with this bank, right? You see what I mean?
I do see what you mean, and I recognize it, but I think when we're trying to resolve the dispute for appellate purposes, since we're unsure as to what they meant, and all doubts on appeals have to be resolved in favor of affirmance, and additionally on motions for attorney's fees, where all doubts are resolved against awarding fees, the fact that they didn't properly plead in their answer in violation of the rule is something that should be resolved against them.
Not sure that concept applies.
Taking that argument though, even taking the general denials, how do you distinguish this from Grosso, Venezia, and Elkin, where there was still disputes, but there was never judicial termination? They were not parties to the contract.
Absolutely, Judge. Because in all those cases, and I read them all those cases, the only issue was the plaintiff bank's attachment to the note and mortgage. It was always, well, the bank pled they were a party, but they're trying to get out of it. There was a voluntary dismissal, so it wasn't an adjudication. All those cases involved the plaintiff trying to unbound themselves to the contract. None of them involved the defendant trying to unbind themselves. And Red Road Residential, the 30 state case that was cited by the trial court, and as I said, not cited by the appellants in their initial brief, that's the only case out there that specifically talks about what happens when a defendant denies signing the loan documents themselves that appear to bear their signature. Now,
so you would agree then that your argument turns on that determination, whether or not there was a dispute here raised by the defendants as to whether they signed the contract at all.
Well, in this case, the trial court's holding was that they denied signing the note and mortgage at all. That's what the judge, I think it was Judge Mike Murphy, but Judge Murphy said that was his holding. He said they denied signing.
Counsel, I mean, we can see the documents just like the trial court can. I mean, this is right. I mean, we're basing it on the pleadings. So why is that entitled to any deference?
Well, we're talking about the standard of review. Well, the reason it's entitled to deference, in this case, as I said earlier, is obviously the preservation issue, the fact that it's not challenged in the initial brief. But in terms of review, it goes back to just the general law. Even if this court were to use just de novo review, parties are bound by their allegations in their pleadings. That's quite standard law.
So you're arguing the failure to parse out that general denial, the significance of general denials, and whether the general denial here was a denial that he signed the contract, et cetera, because that was a finding that appellant has waived that issue because they have not demonstrated error as to the significance of a general denial.
Basically, yes. That the court held that the trial court held they were bound by the general denial. It wasn't disputed in the initial brief, but it's also the correct application of law, even if it was raised improperly before the court, because they're bound by their pleadings.
Let me ask you this: in the hearing on the motion to enforce fees, there's additional evidence entered. Why can't the court, general denials aside, consider the evidence anew at a motion to enforce to determine whether or not the plaintiff or the defendant has satisfied its burden?
The court, well, it's an interesting question of law of what happens, and the trial court talked about, can I consider evidence post dismissal and whether or not you're still bound by your pleadings after the dismissal. And I think in this case, the court said, notwithstanding the fact that I have a document in front of me that says note, and it seems to have the borrower's signatures on it, and I have a document entitled mortgage that has the borrower's signature on it, because the pleading said, I deny all allegations, including signing that, you can't meet your burden. You can't meet your burden to plead and prove you signed the note and mortgage defendants and loan modification agreement in this case, because you denied signing them in your answer through the general denial, which you're stuck with. Well, so this case really comes down to the general rule that all the attorney's fees are disfavored, all doubts are resolved against awarding fees, the presumption of correctness of the trial court, and simply the fact that the trial court got it right, that they are bound by their denial. Otherwise, why would any borrower's counsel actually respond to the complaint as required by Rule 1.110 if they could just do a general denial?
Because counsel, you would force them to do so via motion.
I'm not sure. I mean, I'm not sure what rule a motion would be on. If they chose to plead that way, that's how they chose to plead. I don't know why the burden would be on the plaintiff to force the defendant to correct their pleading.
Counsel, why isn't there argument at page 9, 10, and 11 that, hey, look, there was no judicial determination? Why isn't that addressing the trial court's reasoning related to sort of their pleading, right? I mean, essentially, it seems like their argument is, look, what we need to look at is a judicial determination, and there was no judicial determination.
There was no judicial determination in this case, but if you actually read pages 9, I mean, when you actually look at page 9, 10, and 11, they're talking about a judicial determination as to the bank's standing, as in how there was no judicial determination that the bank lacked standing. That's true. And I've never once in this presentation or in my answer brief really tried to pull a page and try and say, hey, we didn't know judicial determination, so we shouldn't be tagged. The problem is that they don't raise the proper issue, and that should be how they should be bound by that. With that, Your Honor, if there's no further questions, we would ask that the order be affirmed.
Counsel.
Thank you.
Okay, counsel for the appellant, you have, hold on a second, the clock is resetting. There we go, 7 minutes and 53 seconds. You're recognized whenever you're ready.
Sure. I know that there was a mention again of the Grosso case, and the Grosso case actually in the dissent mentions the fact that there were denials as to both parties being parties to the Grosso note and mortgage. And even with those denials, the Grosso court still found that there was an entitlement to attorney's fees based upon the evidence that had been presented, which was the copy of the note and with attached to the complaint and the both.
It just seems difficult, right? I mean, what happens? So it's all fun. Maybe that works and it's easy when there's evidence, but the evidence is undisputed. What happens when there's disputed evidence? Dueling affidavits. What does the trial court do at that point?
I think the trial court has to do what it always is to do, and that's to weigh the evidence and to evaluate.
Hold on. It's going to weigh affidavits?
It's going to weigh the evidence that's presented to it. So if you have an affidavit, you'll accept that affidavit as true unless there's some sort of deposition testimony or other evidence that contradicts.
And let's say that there's dueling affidavits, right? Affidavits that are properly sworn and submitted that are inconsistent. That's kind of an odd situation that we're going to weigh the evidence based solely on affidavits, right? That's kind of unusual.
Right. At that point, I don't think we would then have to go beyond the actual affidavits that were submitted, because in that particular situation, there's no requirement, as Grosso cites to a case that Mahaly versus LaSalle Bank, that says an evidentiary hearing is required for determining the amount of fees, not for determining entitlement to fees. So there's no absolute requirement of such an evidentiary hearing to determine.
No requirement, but it still might be required in the event that there's dispute, right?
Sure.
I mean 57-104 specifically, 105 specifically contemplates entitlement or evidentiary hearings on other ways for entitlement, such as, frivolous pleading, et cetera. So it's not precluded.
Sure, and I completely agree. There is no preclusion of it, but in a situation like that where there is a dispute, I would argue that it would be incumbent upon the parties to present such evidence either through live witnesses or documents to the court. Notably, in this particular case, there was no evidence or contradictory evidence submitted at the fee hearing indicating that somehow either party was a non-party to the agreement. So
what is your response to the argument that the trial court's determination really turned on the general denials, and your initial brief doesn't explain why that determination was an error?
Well, we do, as was noted in page 20 of the initial brief, which talks about that there was record evidence that the homeowners were parties to the contract. Now, the trial court in its order relied upon the Fernandez case, which talked about admissions by parties. And that makes a lot of sense in that you have, whenever a party makes an admission in a pleading, well, it's not incumbent then upon the other party to prove up something that's already been admitted. But that same logic has never been applied to denials. In fact, the First District Court of Appeal way back in 1966 in the Hines case said that a allegation in a pleading should not be considered as fact.
Well, counsel, shouldn't you, if the fact is true, aren't you required to admit it?
Sure.
If your client signed the note, aren't you required to admit that?
Sure, there are requirements to admit and deny, and I agree that the way that this particular answer in affirmative defenses was filed it does not outline specifically each and every enumeration, but I also agree that it was incumbent upon the plaintiff to move to strike the pleading, which it could have done under Rule 1.140 to be able to cause a better pleading to be filed. The main point is that we've properly preserved this issue. It's been raised consistently both in the motion to tax fees and costs. It's a red herring trying to say that we never sought fees under the 57-105 subsection 7, the statute, as well as under the appropriate documents, the note and the mortgage. And then at the hearing itself, there was that evidence that was tendered to the court, including the note, the mortgage, the assignments of mortgage, the affidavit.
You pointed us to page 20 of your initial brief regarding your argument directed toward your general denial. You clearly address the affirmative defense, right? Yes, there's no doubt. But as far as the general denial issue, you pointed us to page 20 of your initial brief. That seems to be directed to the argument that a trial court can consider evidence after voluntary dismissal, as opposed to an argument that you did not deny signing the note mortgage in your general denial.
Right. So it continues on from 20 to 21, which states that in the first full paragraph on 21, the second sentence, the copy of the promissory note and mortgage are proof that the homeowners is a party to the contract because the homeowner's initials and signature is on both documents. That was the evidence. There was clear evidence that the signature and the
that
initial.
address the question though of whether that proof negates a previous general denial.
Well, it does negate a previous general denial because there's no evidence or proof to support that general denial. There's no evidence in the record to say, oh, these homeowners did not sign the note and mortgage. The whole entire defense strategy in the Red Road case, which is relied upon by the appellee, was that this was a forgery, that they were not the correct parties to the agreement. In this case, there was nothing like that. It was defenses raised upon standing and failure to comply with conditions precedent. And you can't have both of those.
Is your position that, look, by arguing that the third element is met based upon the lost note affidavit, et cetera, that implicitly that's an argument that the trial court's reliance on your general denial to say the third requirement is not met, sort of an implicit argument that, hey, look, the trial court looked at the wrong thing, should have looked at the evidence. Is that what you're saying?
Yes, because even
it's not really express in here. It might be implicit, but it's not expressly stated as such.
Mm-hmm. And even looking at Florida Statute 673.3081, that particular statute requires that if there's going to be a specific denial of a denial related to executing documents, it has to be specific. And there is no specific denial that's required here. So our position would be that the trial court
well, and I'm referring to your initial brief, not your pleading. I'm referring to the argument made in your initial brief and whether that was sufficient.
Right. Our position is that it is sufficient because we outlined why the trial court got it wrong in denying the motion for attorney's fees and costs, and why it, based upon everything that was in the record and everything in the precedent in some of the sister courts of this state, why we should be permitted to proceed with that. So I see my time has expired. Thank you for the court's time.
Thank you, counsel. All right, and well argued on both sides. And with that, we are adjourned. Thank you.